Hello, everybody. We are going to be going over Karmelo Anthony's motion for a new trial. Now, a lot of people are saying, oh, this is going to be the motion that just undoes everything that happened in the Karmelo Anthony trial. Well, it's not. It is not going to be the motion that undoes everything. It is something that every defendant that loses at trial makes a motion for. Corey Richins is making the same motion. A motion for a new judge, recusal of that, somebody else hear the new motion, and then a motion for a new trial because, the judge is awful and horrible and biased and all the things that every defendant claims. So this is not the end all be all. What will happen is that this will probably get denied, and then they will move to their appeals with the Supreme Court of Texas. And then if they want to go up further and see if the U.S. Supreme Court will take it, they can try that. That will probably be done. Then they'll probably try, motions for relief and stuff like that, like Mackenzie Shirilla is trying to do. This is not a new concept. So I just want to state that at the top. Now, let's bring up this motion. Actually, first, let's do this. Okay. I didn't have time to share this out, so we are doing that. So let's bring this up. Now, also, when you're coming in, don't forget to hit the like button. Comment if you're on replay crew. Let me know your thoughts and opinions in the chat if you want to do that. And let's get this show on the road. Trying to see. Let me embiggen this more. There we go. So here we have the state of Texas versus Karmelo Anthony in the 296th district or judicial district court in Collin County, Texas. This was filed on July 7th. And so that is what happened here. Oh, that's why I minimized everything. Defendant's motion for a new trial and brief in support. Now, this is just the motion for a new trial. It is long, but part of it is a transcript from an interview that the judge did after the trial. When the trial was done, he did this. To the honorable judge of said court. Comes now defendant Karmelo Anthony by and through undersigned counsel in pursuant to rules 21.1 through 21.9. Now, his appellate attorneys are doing this pro bono. So Texas Rules of Appellate Procedure moves the court to set aside the judgment of conviction and sentence and grant a new trial. The defendant moves for a new trial on 4 grounds. 4, the court committed structural error when it materially restricted public access in violation of the right to a public trial, which the thing is that's to me not going to win the day, because it was open to the public. It just wasn't like a huge courtroom and certain things. I don't know that that's going to win the day, but you can try. That's why a lot of places here in Texas, a lot of places don't live stream trials. It sucks. I hate it as well. But I don't know that it's going to be a winning an argument on appeal. Second, the state's repudiation of parties' unrecorded evidentiary agreement after the defense relied on it. Coerce the waiver of Mr. Anthony's right to testify and deny him a complete defense in violation of his constitutional rights. What? So Karmelo wanted to testify and his attorney said no. He says the state. Repudiation. The repudiation of reformist policies. His current position implies a repudiation of his earlier expressed denial of the truth or validity of something. The refusal of, okay, I don't. So let's read that again. Second, the state's repudiation of the party's unrecorded evidentiary agreement after the defense relied on it. Coerce the waiver of Mr. Anthony's right to testify and denied him a complete defense in violation of his constitutional rights. So they're saying he was coerced into not testifying, is the way I'm reading that. And we'll see what they have to say about it. But just because you say something doesn't make it so. We learned that yesterday. Third, the trial court improperly instructed the jury on the applicable law. Fourth, the cumulative effect of these errors warrants a new trial in the interest of justice. Introduction. Hello, Texas Packet. This case presents a structural public trial violation. The court had authority to manage courtroom security, decorum, and capacity. But once it adopted and administers restrictions and that foreseeably exclude members of the public from a high-profile criminal trial, it was required to make a record supported findings and to consider reasonable alternatives to closure. The court did neither. The access regimen limited public attendance to narrow daily admission period, a small number of seats, and no continuing overflow or audio or visual access after jury selection. Because that closure affected the trial proceedings themselves, and for the 3 additional grounds set out in this motion, defendant asked the court to set aside the judgment and grant a new trial in support. Defendant shows the following. Okay. I mean, he made an order. I think people looking outside, what was going on outside, and some of the shenanigans that people tried to pull in court, sadly makes what happened, what the judge decided to do, a thing. Just as well as they can close the court off when minors are testifying. If any of you watched the Karen Reed trial, you know that when John O'Keefe's niece and nephew were testifying, everybody was kicked out because they were a minor. They didn't need to be live streamed, different things like that. Defendant's motion for new trial and brief in support. Factual background. A, the case and the verdict. This case arises from an altercation at a high school track meet. The defendant, Karmelo Anthony, was charged by indictment with murder of Austin Metcalf, alleged to have committed on or about April 2nd, 2025 in Collin County, Texas, which was Frisco. Frisco's the city, Collin County is the county. The defendant pled not guilty. His defense at trial was self-defense, that he used force he reasonably believed immediately necessary to protect himself. The court's charge submitted the offense of murder, the lesser included offense of manslaughter, and the law of self-defense, including the justified use of deadly force. The defendant did not testify. On June 9, 2026, the jury found the defendant guilty of murder, and the court imposed a sentence of 35 years confinement. Actually, yes, the court imposed it, but the jury selected it because Karmelo chose to have the jury decide his sentencing and not the judge. These matters appear from the indictment, the court written charge, and the judgment. The case drew national attention from the outset, and the court appointed a public information officer to assist with media credentialing, communication, and access logistics. In practice, public and media access were administered through the process, Exhibit 1, Exhibit 7. What follows is how that access was in fact administered before trial at the perimeter of the courthouse campus, at the courtroom door, and after the verdict. Judges are allowed to put some certain restrictions on there. Secrecy before trial, the gag order, chamber conferences, and no public pretrial hearing. The closure of the prosecution to public view began more than 10 months before trial on July 28, 2025. Acting sua sponte and on no party's motion, the court entered an order prohibiting extrajudicial statements, a gag order binding the parties, their attorneys, witnesses, law enforcement personnel, courthouse and court staff, and court-appointed officials, which by its terms remained in force through the trial. And then it says the attachments. Covered persons with firsthand knowledge were restricted from speaking publicly about the facts, evidence, witnesses, and expected testimony absent written approval from the court. There's usually gag orders put on a lot of high-profile cases, especially when people are making it into something that it maybe shouldn't be and are causing drama. Judges don't want things to be tried in social media. Going back to Karen Reed. Like I said, this is not necessarily a special case where things happen in this case that don't happen in other cases. Those who watch a lot of trials and follow a lot of cases know that there wasn't anything just crazy that happened in this case. It really was a simple case. Now, people decided to make it not simple, but it really is. The gag order's terms were sweeping. Unless first approved in writing by the court, no covered person could make any extrajudicial statement that addresses the character, credibility, expected testimony, guilt, or innocence of any party or witness that discusses evidence anticipated to be introduced at trial or that intends or is likely to influence public opinion or potential jurors. Restrictions expressly applicable to any public medium, including traditional news outlets and social media, and enforceable by contempt, fines, attorney discipline, or other remedies. Its findings were 3 sentences. The media coverage has the potential to cause imminent and irreparable harm to the defendant's right to a fair trial. That alternative measure, venue change, juror screening, sequestration, would be inadequate alone. And that narrowly applied speech restrictions are necessary to protect jury impartiality. Let's talk about Tyler Robinson's case that was going through preliminary hearings this week. And what they don't want out and what they do want out and all that. The state is like, let's show it all. And the defense is like, how about no? Let's not. Also, you know what happened in the Aaron Spencer case when the judge tried to unconstitutionally gag people? Which what was done here I don't think is unconstitutional. That's for an appellate person to figure out, but they went to a Supreme Court and got them to do something about it. None of that was done in this case. They could have appealed the media decision if they wanted to. Hello, Razmataz. Yeah, this was nothing like the Aaron Spencer case. We will consider you. You got Texas in your name. That's right. I mean, we're going to be in this comparing a lot of cases to arguments you're making because it is important to point out other cases that had something worse or less than you. You've got to make the comparison. You can't just singly do that. Law is all about comparing one case to another case to another case. That's why there's citations. No evidence is recited. The order permitted only procedural announcements, e.g., hearing schedules, court filings, and statements required by legal or ethical duty, a safe harbor, and a presupposed filing the public could see. By its terms, it would yield only to further written order of this court. The amended order later reaffirmed it until the completion of trial. In the 10 months it operated, no person was ever alleged to have violated it, so far as the public record reflects. Great. It did go silent. I'll tell you that, because you didn't really hear much about it until it was starting to ramp up towards trial. Like there was things that came out a little bit like, oh, there was this, but it wasn't like crazy. And I'm somewhat local to the area because I wanted to see more. And they're just, because it was kept out, we just weren't getting updates that we see in other cases. 6, the substantive pretrial work of the case was then conducted out of public view. The parties' pretrial conferences with the court included a May 21st, 2026 conference in chambers at which the parties' evidentiary understanding was described to the court, and a May 29, 2026 meeting addressing trial security and scheduling occurred in chambers outside open court. No reporters records of them exist, a matter the hearing will confirm. No pretrial hearing was ever held on the access restrictions, and the register of action reflects no such setting. The public docket discloses no motions in limine and none of the substantive pretrial litigation that in fact occurred. Filings that were hand delivered rather than filed in the district clerk's public record. And he lists exhibits. A member of the public who examined the docket before trial would have found no hearing to attend and nothing to read. I get your problem with this. I have a huge problem with Texas courts and the way the public can see and not see. Not really. Like we did, like it was a big thing when it first came out, when the incident happened, and I reported on it like right after it happened. I made my first Karmelo video like a few days after it happened, within that week. And then after that, there was some footage shared for a little bit, and then a lot of it died down. Yeah, I want the stuff that I'm after. I need it. I have stuff I want to look into. So I understand some frustration. And yeah, that would have been nice for the public to be able to see when a hearing was, on the docket. So if they wanted to attend it, they could. The amended order, the written terms of access. On May 18, 2026, the court signed the amended order regulating trial proceedings, media access, security, courtroom decor, entered to govern all aspects of the trial proceedings. The order recited the directives of Waller v. Georgia and Shepard v. Maxwell, found that unrestricted access or activity may compromise courtroom security, juror privacy, and the defendant's right to a fair trial, and promised reasonable public access consistent with constitutional requirements. Yeah, they're going to be minimal. Its operative terms were these. The courtroom would open at 8:30 a.m. for the media, at 8:40 for designated family members, and at 8:50 for general public. No more than 9 members of the media would be admitted. Seating would be on a space available basis. The doors would close promptly at 9 a.m. Individuals arriving after that time would not be admitted until a recess, and no person who left could re-enter except at a recess. All persons attending were required to dress in appropriate business attire. Yeah, you dress for court like you would dress for church. Hats and caps were prohibited, and clothing or items displaying messages, logos, symbols, or images related to the case or otherwise distracting or potentially prejudicial were banned, as they are in most courts. Why do you need to come into court looking like a fool? Or why do you need to come into court with your pants on the ground? I mean, there was a whole song about pants on the ground, looking like a fool with your pants on the ground. I mean, it was a song. All right. The order appointed Steve Stroller, identified in the order only by a personal email address and a cell phone number, as the court appointed public information officer, committed media credentialing to that office, and announced that the court will not intervene in or resolve disputes among members of the media regarding access or seating. The order contained no provision for an overflow room, an audio feed, a video feed, or any other means of observation for members of the public turned away, and no mechanism by which a member of the public could be heard to object to any of it. A member of the public isn't going to get to object to any of this. Like, you can't participate in the proceeding. A lawyer can. And if the family has objections, then the lawyer can do something then. But members of the public, no. And media didn't have a reason to come in and object because they were allowed. There might have been some objection in the beginning, but I don't remember if it was or not. I know the media wanted access, but the order also closed the court grounds themselves. It placed the entire courthouse campus, including parking lots, sidewalks, green space, or any other designated area, under a nightly curfew from 11 p.m. to 6 a.m., beginning May 31st, 2026. Yes, because what business do you have being on courthouse grounds during the late hours? You don't. That's not unusual. Many courts do that. It designated restriction zones on an attached exterior map, and it ordered the Collin County Sheriff's Office and other law enforcement personnel to ensure compliance with this order at all times during the trial. Yeah, there was a map in the Karen Reed trial too. And you couldn't even go within like the parking lot or sidewalk or green area near the courthouse with any shirt supporting anybody. Talk about restriction. Y'all at least got to stand outside and do things. That was not allowed in Karen Reed. Okay. Under the Orders Enforcement Clause, any violation, including citizens' presence in a courthouse parking lot or on the green space beside the courthouse before 6 a.m., expose the violator to immediate removal from the courtroom, courthouse, and courthouse grounds. Yeah, follow the court rules. The imposition of sanctions, including contempt of court, and no warning is required prior to the enforcement. Well, the warning is these are the rules. Break them, you're in trouble. They're not going to be like, hey, you know, you're not supposed to be here. No, there was an order and you're expected to know that. Just like if you go travel to another state or a country, for sure, you need to know what the laws are there. Because you're not necessarily going to get a warning if you break the law somewhere. The law itself is the warning. No findings of any kind accompanied the curfew. Access and operation, the curfew, the parking lots, and the pre-dawn line. In operation, admission had almost nothing to do with the orders stated 8:50 a.m., public entry time. Because the public seats were few, members of the public began arriving in the pre-dawn hours, often between 4 and 5 a.m., before court was in session and while the campus curfew was still in force. And sheriff deputies enforcing the order stopped arrivals at the parking lot and restricted entry on the campus until the curfew lifted at 6 a.m. Yeah. The queue that actually determined who would see this trial thus formed a perimeter of the courthouse campus hours before any proceeding convened. A member of the public who appeared at the order's appointed hour of 8:50 a.m. had, as a practical matter, no prospect of a seat. That's their fault. The line itself was administered without published standards and not evenly handed. Even-handedly, individuals were permitted to move ahead of members of the public who had already waited for hours. Yeah, I know that Sarah Fields herself had an issue with people cutting. There was cutters, and that's not right. I don't like cutters. But says Thelma Anderson, who arrived early on June 6th and initially held approximately the 7th position, was displaced to approximately 35th, beyond the number of available seats, and was excluded from the morning's proceedings. Tamitra Carter, identified as number 7 on an early arrival list, was removed from the line on June 5th and lost the morning session. Admission was run through 2 lines, one for a media list, one for everyone else. The media outlets denied credentials were directed by public information officer to seek entry through the public line. Whereas a Collin County sheriff's deputy administering the line acknowledged on video, persons who print out whatever and make themselves like they are media consumed public few seats, a practice the officers concede they could not police. There could be journalist credentials, media credentials. Grounds. Yeah, dress appropriate. Inside the courtroom, 24 public seats and an overflow room provided and then withdrawn. The court held approximately 70 seats. By the court-appointed public information officer's own written account, 15 were allotted to the prosecution's family, 15 to the defense's family. That's even-handed. They were given 15 and 15. So the people that needed to be there and see it, like the families didn't have to like wait in line for the public and possibly not get in. They were allowed in. They had reserved seating. 9 to the media, including a courtroom sketch artist, with additional seats for court staff, leaving about 24 or so seats for the general public. The trial judge later confirmed the arithmetic on television, some 200 requests by the media and 27 to 32 public seats that we rotate every day. None of these allocations appear in any order, and the 15-seat family allotment was not honored in practice. The defendant's own family was limited to 8 seats in total, so his grandfather and his aunts were excluded from the trial, while those admitted were required to register a day in advance and were warned that a visible facial expression could result in a removal. Yeah. If the Metcalfs were making faces and stuff like that, they would need to be removed too. You can't be acting out. Where's your proof that they were only allowed 8? And you know what? The state gets to respond to this as well. So we will see the state's response. For jury selection, the court furnished what its order had never promised: an axillary viewing location outside the courtroom, a functioning overflow room, where members of the public who could not be seated inside observed the proceeding on June 1st and June 3rd. On June 4th, the first day of testimony, the court eliminated it. No announcement was made in open court, no order was entered or modified, and no findings were made. Public access was therefore confined to the seats inside. Well, maybe there's a reason they just did it for jury duty. It's not a requirement to have an overflow room. Okay. Nor was the elimination a reaction to anything that occurred at trial. As early as May 25th, 2026, the public information officer had advised an inquiring journalist in writing that there will be no overflow room during the trial. This, although the county's own media request intake form listed overflow room access among the accommodations that would be requested. When Thelma Anderson asked the court for an alternative viewing location, there was no way even to file the request. The county's electronic filing system had no category for courtroom access required in a criminal case. So the request was routed by email to the court coordinator and onto the public information officer, and it was denied outside any judicial proceeding. On June 5th, the public information officer confirmed in writing there is no overflow room. The pattern is visible day by day. During jury questionnaires and voir dires, June 1st and June 3rd, an auxiliary viewing room accommodated the members of the public who could not be seated inside. On June 4th, the first day of testimony, the room was eliminated. And on every documented day of testimony thereafter, members of the public were excluded. The accommodation existed precisely when no witness was testifying and vanished precisely when the evidence began. So it talks about Monday, June 1st is jury questionnaires, auxiliary viewing room available outside the courtroom. At least one member of the public turned away on a purported jury members only rule. June 2nd, nothing because the courthouse was closed. June 3rd, it was voir dire, auxiliary viewing room in operation, the overflow public observing the proceedings from it. Let's see here. June 4th, testimony begins in the state's case. The viewing room is eliminated without announcement or order or finding from the line of roughly 80 to 100, approximately 27 admitted. Yon, Allen, and Anderson were excluded. Friday, June 5th, state's case. Anderson excluded, Carter removed from the line and denied the morning session. PIO confirms, which is, I guess, the personal media person. In writing, there is no overflow room. Saturday, June 6th, state rests defense case begins. Anderson displaced from approximately 7th to 35th in line and excluded until mid-afternoon. West removed from the courthouse for expressive clothing. Yeah, because you can't be doing that. That was a broken rule. And why does this person keep getting moved out of line? Like, what was the reasoning? Is it because she gets out of line and nobody's saving her spot? I mean, they're saying it's cutter peanut butters, but I don't know. Monday, June 8th, defense case resumes and concludes. Shortened day. State reputes the parties' understanding. Defense rests. Jurors sequestered overnight in a hotel. Charge set for Tuesday morning. Same, no overflow, no audio, no video access regimen remaining in effect. Public access, if any, remain limited to the courtroom, seating, and pre-dawn line administration. Further facts to be developed at the evidentiary hearing. If you're even going to get an evidentiary hearing, a lot of times this stuff is determined on the papers. Tuesday, June 9th. Charge, closing argument, 3 hours of guilt, deliberation, guilty verdict, and the entire punishment phase, at which the state called no witnesses through a 35-year sentence all the same day. And then it says, same, no overflow room, no audio, no video access. Regiment remained in effect for charge. Closing arguments guilt, deliberations, verdict, punishment, and sentence. No contemporaneous alternative access was provided for those not seated inside. And they're going to go to excluding the public. This is a huge, public information officer. Yeah, the media guy. I agree, Razmataz. We need cameras in the courtroom. There are a lot of states that are bad at it. DFW area is not great at it. There are some Dallas courts that do have it. I know there's one. That judge pisses me off a lot because I think he's pro women and not like against males, but I think he's kind of biased. He's like a family court judge. And then we had a little bit of it opened during the 2020 time. And then like the Houston area has tons of people. Like Judge Fleischer and I believe Judge Boyd is down there too. Bear County. Yeah. So we have some great judges down in that area, but DFW is like, nope. The 2020 time period is over. We are not going to have open courts. The exclusion that followed were repeated and concrete. Jacqueline Yon traveled from North Carolina and on the first day of testimony found a line of roughly 80 to 100 people, from which only about 27 were admitted. Tira Allen flew in from Arizona. Observed jury selection from the auxiliary viewing room, was told on June 4th that the room had been eliminated and was excluded from the courtroom. Okay, who are these people? Doesn't sound like I don't know if they're family or not, but let's see. Bridget Smith attended on June 4th, 5th, and 6th and confirms both that roughly 27-seat public cap and the elimination of outside viewing location once testimony began. Kiera West was turned away on June 1st on a purported jury members only rule and was physically removed from the courthouse. On June 6th, because of expressive content of her clothing, so Kiera West, she's been kicked out twice. And maybe where she was at was where she wasn't supposed to be. I don't know if she had a phone in the courthouse or what she was doing, but there were problems. I don't know if she was a family member or not. But when I tell you most of the people that were outside raising all kinds of hell outside that courthouse, most of them were not local, because that is not how people in that area conduct themselves. Thelma Anderson was excluded on June 4th, 5th, and 6th, was seated only in mid-afternoon after substantial portions of the day preceding had passed. Throughout, no declarant observed any disturbance, security incident, or disruptive conduct by any member of the public that would explain the restrictions. There was some problems outside. And that, those were the problems outside. Had all those people been allowed inside, would they have been acting the same way? Would somebody in the overflow room be telling a person that the only good cracker is a dead cracker in an overflow room? Or would they mind their P's and Q's? The unrecorded agreement. The defense tried its case under that limitation in reliance on an understanding reached off the record. The same off-the-record method that hid the pretrial proceedings from the public also produced the understanding on which the entire defense was built. Beginning in early May of 2026, the lead prosecutor proposed that the parties try the case clean. Yeah. Don't play dirty. Why is that a hard thing to understand? Yeah, his parents left after he was convicted. They did not stay for the sentencing. She was like, "Please save my baby," before they decided the 35 years. She was not there when he was told he was going to be sent away for 35 years. Oh my gosh. The Conor McGregor is fighting. Does Gingras know? Get a drink. Okay. Based only on what happened under the tent that day. No, that is not why the prosecutor said try the case clean. Based solely what happened under the tent that day. He was saying that because people supporting Karmelo Anthony were trying to start bullshit and make this case about something it's not. It had nothing to do. He didn't want to bring any of that BS that actually has nothing to do with this case in this case. So he's saying, based on what only happened under the tent that day, with neither side offering character, reputation, or extraneous conduct evidence concerning either the Metcalf twins or the defendant. One, you're not allowed to bring character evidence of your client. Karmelo Anthony can't be like, I'm a good person. And that's the thing is Carmelo can't be like, hey, a few years back, I saved somebody from drowning, which great that he did that. That's wonderful. Um, and the state, could they put up that, Metcalf's this or Metcalf that? Yeah. But they were like, you know what? Let's not bring in suspensions, which those got put in. But they weren't going to bring in all this extra stuff. They wanted to focus on what happened that day. I don't give a shit about what was going on in their past, if they were suspended, if they've gotten in trouble with the law or anything else. Like, let's just focus on April 2nd and what happened under that tent at the track meet. The terms were negotiated in meetings and calls on May 5th, May 8th, May 11th, and May 21st, 2026. The parties presented the understanding to the court itself in chambers off the record. To avoid media reporting on bad act evidence, the understanding was memorialized only as deliberately generic motion in limine, hand delivered to the court on the first day of trial. It does not appear on the public docket. Yeah, but does it appear on the docket, period? Maybe you have to request it. Not really much to see on public dockets anywhere. From the point forward, the defense tried its case under that limitation at every stage in reliance on the bargain. Yeah, the defense agreed to it. They weren't against it. Because there's stuff that they didn't want people bringing in about Carmelo. Because it didn't matter what he's done in his past. It mattered what he was doing that day. And character evidence is a huge thing. They're like, oh, the generally bad guy rule. oh, if he did this, he probably did this. They weren't going to play that way. So he's saying, the defense was limited at every stage in reliance on the bargain. In voir dire on June 3rd, the defense did not explore with the panel the themes of decedent's character and aggression and it otherwise would have developed. In its opening on June 4th, it introduced none of them. Through the state's case on June 4th, 5th, and 6th, the defense let the state's student witnesses leave the stand without confronting them with their own recorded statements to police. The Austin Metcalf was kind of like the aggressive guy on the team, that he got triggered, that Austin and Hunter, they're not going to let you disrespect them. And that if Austin is about to get in a fight, you can tell. And that he could be a bit aggressive at times. And in an abundance of caution, even narrowed the questioning and understand permitted, the defense designated no experts, foregoing a neuropsychologist prepared to explain how the defendant's epilepsy affected his perception of threat. What? So now epilepsy makes you view threats differently? Guys, we have unlocked Laura Owen's problems. This is why she has so many restraining orders. Is because of her epilepsy. She has the perception of a threat different than people without epilepsy. She finds things more scarier. Secret unlocked. Secret unlocked. It all makes sense now. She should have wrote a Medium article about this and not autism explains everything. It's epilepsy explains everything. Holy shit. Have you been talking to Gingras, appellate attorney? So the defendant's epilepsy affected his perception of a threat, and a forensic psychologist prepared to address adolescents' brain development and the fight or flight response, because the state took the position that such testimony would breach the understanding. The forbearance had a purpose. The payoff was to come in the defense case, under the understanding, as the prosecution itself repeatedly described it, covering all witnesses to what happened under the tent. The defendant would testify to the altercation like any other tent witness, free of character impeachment, and the defense would present its self-defense case through him. Then they should have put him on the stand. The defense decided to call 0 witnesses. The court didn't make that determination. The defense attorney did. And I expect to see one day ineffective assistance of counsel as one of his appeal things. Every pretrial discussion presupposed it. The prosecution repeatedly raised the ambiguous aggressor doctrine that matters only in a self-defense case built on such evidence. And as trial counsel has sworn in this case, the defense would ordinarily depend on the defendant's own account of his perception of threat. Yes, that has to be shown. There has to be evidence for a jury to determine that, but there was no evidence of it. There was nothing. The holes weren't poked into any of that. Maybe because there was no reason there was no way for holes to be poked in it, or the attorney just sucked. I mean, it could be either one. But it is not reasonable to think that if you get shoved that you can stab. And if you think that that's okay, then you need to go seek therapy and a psychotherapist as well. On Monday, June 8th, the final day of evidence, after the defense had spent voir dire, its opening, the entire cross-examination of the state's case, and the first day of its own case, honoring the bargain, the lead prosecutor announced that the agreement had never contemplated a testifying defendant and asserted that defense counsel had already opened the door by mentioning in opening that the defendant played chess, a position the court itself rejected. The court then advised the parties that it knew no mechanism at its disposal to enforce their understanding, and an understanding that, throughout the months the defense relied upon it, existed on no record because it had been reached and presented to the court off the record, and that if the defendant testified, the door to character and extraneous offensive evidence would almost certainly open. It says allotted 10 minutes. The defendant elected not to testify. That was his choice. If he is going to get up there and he is going to open the door by talking about Austin Metcalf's character, he's going to be questioned about his character. Things like that will open the door. There's a reason a lot of defendants don't normally testify, because if they do, lots of things get asked and it opens tons of doors and cross-examination that most defendants don't want in their trial. By then, it was too late to conduct a different voir dire, deliver a different opening, or recross the state's witness. And at punishment, the defense case was reduced to 3 pre-approved questions of the defendant's mother. That's the case that the defense decided to put on. And if there should have been something that was supposed to be put on the record, it needed to. You also could be lied to. But I don't know. I don't know where you're getting this information. If everything is so off the record, you're getting it from somewhere. The state, for its part, called no punishment witnesses and offered none of the extraneous offense or character evidence cataloged in its 75-page notice, resting its punishment case immediately, exactly as the lead prosecutor had described on May 11th, that the agreement would operate. The state's punishment presentation will be confirmed by the reporter's record. The state thus performed a bargain at punishment the day after denying the same bargain covered the defendant's testimony. In the end, neither side put on character evidence. Yeah. You don't do it, we don't do it. If you're going to do it, we're going to do it. That's a pretty simple understanding, and I don't think it's anything crazy. It happens. You want to sit there and place blame and bad shit on other people? Well, guess what? Your can of worms is getting open too. Let's see. The understanding covered. The bargain was performed on both sides through the last day of the trial. The only term reputed was the one most vital to the defense, the defendant's own testimony. Karmelo Anthony was necessary witness to what happened under the tent, under the understanding as the state itself had repeatedly described. He would testify like any other witness under the tent. His elimination as a witness was devastating to the defense that turned on his own perception of what he of what the threat he faced. You know, if you put your client on the stand, they're going to be asked questions. The other witnesses were asked questions too. By then, the defense had already paid the price of reliance and could not undo the voir dire, opening cross-examination, expert designations, or decision framework that had followed from the understanding. That sounds like attorney problems or miscommunication somewhere. The expedited schedule, Saturday court, and 10 minutes to decide. The trial itself was run at speed. At the May 29th conference, the court announced its intention that the defense began calling witnesses immediately upon the state's resting, so that no trial day would go unfulfilled, including Saturday, June 6th, a day on which several defense witnesses were unavailable. Trial counsel told the court that the schedule could not or could force the defense to call the defendants out of order. Yeah, a lot of people, a lot of judges get pissed off if you're not ready to go with your witnesses. This is nothing new. You better have, because you're given an approximate of when the state's going to rest, you better have a witness ready to have their butt in the seat as soon as that happens after, motion for summary judgment. This is nothing different than any other court case. They don't like wasting the jury's time. And if you have to call a witness out of order, usually the state and the judge will allow it. We see witnesses taken out of order almost every trial. There's at least one or so taken out of order. It's not uncommon. Let's see. Trial counsel told the court that the schedule could force the defense to call the defendant out of order. The state rested midday Saturday, and the defense began its case that afternoon. The reputation of the parties' understanding described above and set out fully in part 4 below erupted on Monday, June 8th, the final day of evidence. When the moment came for the defendant to make the most consequential decision of the trial, whether to waive his Fifth Amendment privilege and testify, the court allotted the defense 10 minutes to counsel a 19-year-old through it and denied counsel's request for additional time. You have had over a year to talk to your client about whether they are going to testify or not. You had from at least Saturday to Monday to talk with your client about whether he was going to testify. We saw this with Donna Adelson. She just wanted more time and more time and more time to just figure out if she was going to testify or not. You've had time to decide. You've had time to talk to your client. Your client was out in the free world, not in a jail like Donna Adelson. You had free access to your client. You didn't have to go through certain rules and all this, no restrictions and all that. You had free range to discuss this with your client and his parents and all that. Him being denied additional time is not going to change anything. The defense rested that day. After the shortened session, the jurors were sequestered overnight in a hotel, informed that if they did not reach a verdict on Tuesday, they would remain sequestered. On Tuesday, June 9th, 2026, the court delivered its charge. The parties presented closing arguments, and the jury deliberated approximately 3 hours before finding the defendant guilty of murder. The punishment phase, evidence, argument, deliberations, and the rejection of sudden passion was then completed, and the 35-year sentence was imposed before the end of the day. This sequestration and deliberate chronology, widely and publicly reported, will be established at the hearing and confirmed by reporters' records. What hearing are you getting? I mean, you can request a hearing. It doesn't mean that it's going to get granted. After the verdict, the sealed file, the missing record, and the televised defense of the closure. The secrecy outlasted the verdict. Trial counsel withdrew on June 10th, 2026. Appointed appellate counsel was then replaced, and present counsel was substituted in on June 23rd, 2026, all while the 30-day deadline for this motion ran. The reporter's record remained woefully untranscribed, and the pleadings and case file sat in the court chambers rather than in the district clerk's public record, sealed by an oral order. At a conference on June 29, 2026, the court advised that the entire court file had been sealed by oral order and conditioned counsel's inspection of it on an agreement not to disclose what he observed. A condition counsel could not give, leaving the file available only in chambers. Interesting. 2 days after imposing sentence, the trial judge gave a televised interview defending the restrictions, describing the decision to bar cameras and streaming as an easy decision, acknowledging that he sometimes thinks maybe he should have at least audio streaming or something so people could hear it, and explained that he declined to do so because people are going to distort whatever happens. So what's the point? The point is so that it can't be distorted, because people wouldn't. But the judge is also right, because even when a trial is streamed, you've got anti-Karen Read people who are like, the trial is this. And most people are like, no, you're crazy. You've got pro Amber Heard people that are like, Depp is the villain. And it's like, no. And you can show them parts of the trial, part of a transcript, all this stuff, so that they can be called out and corrections can be made. But when the public doesn't know fully what all happened, it's going to be very distorted, and things can't be pointed out to try to correct the record. Yes, there are going to be people out there that distort things because they have other agendas. But majority of the people, they don't necessarily have agendas. They just want transparency and truth. So that's the point. And if this is why in DFW area we don't have cameras, because people are just going to distort it no matter what. Okay, let them distort it then. At least you put the transparency out there. In a written statement to Fox News, the judge added, "Now that the trial is over, it is important to me to provide transparency." And in a public letter of June 17th, 2026, he thanked the other judges of the county for adjusting their own dockets to accommodate this trial. At minimum, raising a fact issue about available courthouse space, available staffing, and available alternatives that should have been considered before the overflow accommodation was withdrawn. Maybe. Didn't have to be, though. If that's that judge's courtroom, then that's that judge's courtroom. You didn't have to move courtrooms. Was there a request to move courtrooms by attorneys? Because the reporter's record of the trial has not been prepared, the official court reporter has advised counsel that no portion of the trial has been transcribed. And because the case file has been held in the chambers rather than in the district clerk's public record, the recitation above is drawn from the indictment, the court charge, the public docket, and the court's own orders and public statements, the attached affidavits and declarations, and counsel's knowledge. Defendant will offer evidence at the hearing in support of grounds timely raised herein. Which, where is the transcript? Which I don't. You might have to pay for a rush transcript. Because I don't know that the transcript is complete. Like, I'm thinking about the Corey Richards case, you know? Like, I don't know that they cited portions of the transcript from trial. I think there's a reason that they made, like, citations to video parts in the motion for new trial, because maybe the full transcript is not available yet. I know you have to have it for appeal, but I don't know that for a motion for new trial that you have to have it. And as for the attorney that was for Karmelo during the trial, his job is done when the trial is over. Usually the appellate attorney will, so there's times when the appellate attorney will be the one that makes the motion for a new trial. There are other times when it's the attorneys from trial that will make the motion. And Sarah Boone, we kind of had a little bit of both. Corey Richards, it's her trial attorneys that are making the motion for new trial. So I don't know why that attorney didn't stay on to make the motion for new trial, and why he left it up to the appellate attorney. That's a question. They could have asked for an extension to wait till the transcripts were done to make a motion for new trial. Yeah. Like, if it is the person that was in trial that is making this argument, I don't necessarily think I don't know that you necessarily need transcript for it, because you were in the trial. You know what happened. You can just put your issues there. And this is not like a straight appeal, like where you need all that citation and stuff like that. But if it's an attorney that wasn't in trial, who actually doesn't know what happened in trial other than what he's being told, hearsay from other people, I would think that he would kind of want the record, you know? Because he's just going off of what a bunch of people have told him and what little was given out to the public to try to make this motion. And he still was able to write 193 pages. But I feel like maybe he should know what happened in the trial before he tries to say you need a new trial because of what happened in the trial, if you don't know what happened in the trial, how are you saying something went wrong in the trial, you know? So that's interesting to me. If it was just the same attorney, it'd be one thing, but it's not. So, I mean, it may not be required, but I'm saying that would be nice. I'm all for like what's fair so that the person can actually make valid arguments, not just go off a bunch of people saying whatever they think they is right. Okay. Procedural background, timeline, and jurisdiction. On June 9th, 2026, a jury found defendant guilty of murder. On the same date, the court imposed sentence in open court, assessing punishment at 35 years. Confinement in Texas Department of Criminal Justice Institutional Division. On June 4th, 2026, the trial court signed the certification of the defendant's right of appeal. Although that certification issued before the verdict, the judgment of convictions was rendered and sentence was imposed on June 9th, 2026, and the notice of appeal followed. On June 10th, 2026, the defendant filed his notice of appeal, and the appeal was docketed in the Fifth Court of Appeals as cause number. On or about June 11th, 2026, after the verdict, the sentence, the certification of the right to appeal, and the filing of the notice of appeal, the presiding judge gave a televised interview concerning this case, which aired on WFAA TV Channel 8. Okay. Yes, and when they filed the notice of appeal, they're like, "Oh, they've filed their appeal." No, they haven't. The appeal will probably be more than 193 pages. I'll tell you that. If this is this long. Are you even allowed, and this includes exhibits, but are they even allowed this many pages without permission from the court? Like, I don't know what the page limit is. But I've heard so many judges recently talk about page limits. This seems over the page limit. This motion is timely under Texas Rule of Appellate Procedure 21.4a, being filed within 30 days. After June 9, 2026, the date sentence was imposed in open court. The court retains authority to consider the rule on the motion through the 75th day after the date, and notice of appeal, if any, does not divest the court of the authority until the appellate record is filed in the Court of Appeals. And then they cite case law. Because sentence was imposed in open court on June 9, 2026, the 30th day to file this motion is July 9, 2026, and the 75th day follows on August 23rd, 2026, subject to the rules. Defendant requests a hearing and a ruling no later than August 21st, 2026, to avoid any dispute over Rule 21.8's deadline. Okay, motion denied. Defendant is presented this motion within 10 days of filing, as Rule 21.6 requires, and contemporaneously requests that the court sign the attached order on presentment and set the motion for an evidentiary hearing so that the parties may present evidence and the court may rule within the time. I don't know that you're getting a hearing on this. Most of the time you don't. So, would you like the red carpet rolled out for you as well? Contemporaneously with this motion, defendant is filing a motion to recuse the presiding judge because Rule 18A of the Texas Rules of Civil Procedure governs recusal in criminal cases, citing an Arnold v. State case, an appellate case in Texas criminal courts in 1993. Defendant requests that the evidentiary hearing on this motion be conducted by the judge presiding after the recusal motion has been referred and resolved in accordance with that rule. So do not rule on this motion for a new trial until you deal with the motion for recusal. And they can say, denied. And then they can just timestamp the recusal earlier than this one, and that would suffice that request. The motion is supported by affidavit because it raises matters outside the trial court established by attached affidavits and authenticating declarations and is timely filed and presented. Defendant is entitled to an evidentiary hearing, and the court would abuse its discretion in denying one. I don't know about that. Let's see. A formal request to the court set aside within 30 days of judgment based on legal errors, newly discovered evidence, procedural issues that affected the fairness. It should be done within the 75 days. Let's see what this says. Trial court erred in not holding a hearing on appellate's timely filed motion for new trial because there was an allegation of ineffective assistance of counsel raised on the motion for new trial, and the trial court was required to hold a hearing to allow the appellant to fully develop the record. New trial or hearing is not required on the grounds. Court of Appeals erred in holding that a hearing is not required on the motion for a new trial, alleging ineffective assistance of counsel when a timely motion for a new trial has been filed and raises the issue of ineffective assistance of counsel. Okay, well, you're not bringing up ineffective assistance of counsel, which is what Reyes v. State deals with. So that one doesn't apply, although you're somewhat saying it. Let's see what Roswell v. State. Okay, this one doesn't stand for it either, because this Roselle is about somebody not requesting an evidentiary hearing and wanted one, and so the appellate courts was like, the judge can't err in not giving you an evidentiary hearing when you didn't even ask for one. So that's interesting. So I don't know why he's citing that, which is this one. Let's see here. In Hobbs, let's see here. Where is it? Let me go back because after delay caused by the state amending indictment, administrator because of the trials, determined his request did not interfere. The court did not abuse its discretion in refusing to allow the defendant to withdraw his jury waiver because something. Court of Appeals. All right, let me see what this one is. Part 2. Such a hearing is not an absolute right, but the trial judge abuses his discretion in failing to hold a hearing if the motion and accompanying affidavits raise matters which are not determinable from the record, and 2, establish reasonable grounds showing that the defendant could potentially be entitled to relief. The second requirement limits and prevents fishing expeditions. A new trial motion must be supported by an affidavit, specifically setting out factual basis for the claim. If the affidavit is conclusory, is unsupported by facts, or fails to provide requisite notice of the basis for relief claim, no hearing is required. So all these things to me stand for the proposition that they don't have to grant a trial. So it doesn't say that it's an abuse of discretion to not have an evidentiary hearing. I don't think there's not going to be need for an evidentiary hearing, but we'll see. I could be proven wrong. Do you want to give him one out of an abundance of caution? Sure, but it's just a waste of time and money. Under the circumstances, refusal of holding a hearing would be an abuse of discretion because the motion and its supporting affidavits raise matters not determinable from existing record that, if true, could entitle defendant to relief. State v. Pinkleston. That is especially so here when the reporter's record has not been prepared. The official court reporter has advised counsel that no portion of the trial has yet been transcribed, so the relevant proceedings cannot presently be reconstructed from any existing record. Okay. So maybe because there's not a court record yet? I don't know. First ground for new trial. The trial court violated defendant's Sixth Amendment right to a public trial by materially restricting public access to trial proceedings without defining an alternative required by Waller, Presley, and Strickler. Okay. The issue is not whether the court had authority to manage courtroom security and capacity. It did. The issue is whether, after adopting an access order that foreseeably excluded members of the public from a high-profile criminal trial, the court made the findings in Waller v. Georgia a U.S. case from 1984 requires and considered the reasonable alternatives. Presley v. Georgia, a U.S. from 2010, demands for contemporaneous public access. It did not. The court's order gave a general public only a 10-minute daily initial admission window, left roughly 24 seats for public observers in a nationally watched murder trial, barred meaningful re-entry during proceedings. A lot of times you're not allowed to enter and re-enter the courtroom when testimony is happening. That's in every court that I've seen. If you leave, you're not allowed back in. You can't just go in and out. We're not raised in a barn. And provided no overflow room, no audio feed, no video feed for those foreseeably turned away. Once closure is shown, it cannot stand unless the record contains a Waller complaint justification for those restrictions. The existing record contains none, nor does the danger end with this case. In a televised interview about the case that has drawn national attention, the court publicly defended these restrictions as the right way to conduct a high-profile trial, describing the decision to bar cameras and streaming as an easy decision and stating that I had struck the balance pretty well. I don't think that they necessarily did either. Like, I am not going to disagree with them that there was hardly any public access. I'm just not. And you know what? If this part where it's not going to necessarily overturn his conviction, but they're like, y'all need to allow more access, and that gets stated, it's not going to happen in this court. The judge is not going to be like, all right, you're right, we should have allowed more public in. Karmelo can have a new trial. Like, that's not happening here. It'll have to happen at a different level. It's not here. But I guess go on with your bad self and try. But I'm not going to disagree necessarily with this argument. I'm going to say some of it is not different than other places, though, that we see certain restrictions on cases. Let's see here. Should a trial be held behind 10-minute entry window with no overflow room, no audio feed, no live stream, be treated as an adequate substitution for an open courtroom? The public trial guaranteed the First and Sixth Amendments would be hollowed out in practice. The restrictions here amounted to a closure of the courtroom imposed without the findings the law requires. The defendant does not contend that live streaming is constitutionally required in every case. The issue is that once physical seating was foreseeably inadequate, the court was required to consider reasonable alternatives and make Waller findings before excluding the public. I'll have to look into that Waller case. An open courtroom belongs to the people of Texas who fund and sustain it. The openness of criminal trials is among the oldest and most settled feature of Anglo-American justice. The United States Supreme Court has held that public and the press possess a right, secured by the First and the 14th Amendments, to attend criminal trials, and that absent an overriding interest articulated in findings, a criminal trial must be open to the public. And maybe the articulated findings was the drama in the public. Maybe he thought everybody could behave themselves. It would have been different. We don't know. And then they're citing a bunch of press cases. A presumption of openness inheres in the very nature of criminal trial under our system of justice. For a public trial gives assurance that proceedings are conducted fairly, discourages perjury and misconduct, and guards against decisions based on secret biases or partiality. Citing more case. As the court observed, it would be difficult to single out any aspect of government of higher concern and importance to the people than the manner in which criminal trials are conducted. Texas has long spoken to the same effect in its own voice. The Code of Criminal Procedure commands that the proceedings and trials in all courts shall be public. Texas Code Criminal Procedure Article 1.24. The Court of Criminal Appeals has embraced the presumption of openness recognized in Richmond newspapers, explaining more than a century ago that the Texas Constitution is but in accord with the genius and spirit of our free institutions, which is intended to guarantee publicity to the proceedings of our court. That's a Houston Chronicles thing. The guarantees are not abstractions. They are not held by the accused alone. The open trial guarantee belongs as well to the citizens of Texas, in whose name the prosecution is brought, by whose taxes the courthouse and the court are sustained, and whose confidence in the administration of justice depends on their ability to see that justice is done. Public attendance is the mechanism by which the community observes that the court is funds and are functioning lawfully, a check on official power that the Supreme Court has repeatedly identified as core, purposeful of the open trial guarantee. When the public is excluded from a Texas courtroom without lawful jurisdiction, the inquiry falls on the defendant, whose Sixth Amendment right is violated, and on the community, whose courtroom it is. It is the defendant's inquiry that this motion vindicates. The community's stake underscores why the violation is neither technical nor trivial. I'm not going to disagree. The public trial is staged for two audiences at once. The first sits in the gallery, the citizens in whose name the case is brought, who watch to satisfy themselves that the state proves what it claims and that the accused is not quietly condemned. The second sits on the bench and in the jury box, the judge and the jurors, for whom the awareness of which watched is itself a discipline, keeping them keenly alive to the sense of their responsibility and to the importance of their functions. A 10-minute entry window empties both galleries at once. It turns the public away before it can watch, and it relieves the court of the very audience whose presence is the discipline. What the order described as access operated in practice as material exclusion. History explains why the law guards the open courtroom so jealously. The public trial guarantee is a long-standing safeguard against secret proceedings. It has always been recognized as a safeguard against any attempt to employ our courts as instruments of persecution. What openness protects, secrecy endangers. A proceeding the public cannot watch is one in which the ordinary checks on error, overreach, and bias quietly fall away. That is the structural risk a closed courtroom creates, whether or not anyone can later prove the harm the secrecy concealed, which is precisely why the law treats the deprivation as a structural and does not put the defendant to proof of a hidden injury. A courtroom may be closed only rarely and only on the showing Waller requires. The most directly applicable appellate authority on this precise question is a published decision of the Court of Appeals handed down months before this trial began. In Strichter v. State, the Fifth Court of Appeals held that a trial court violated the defendant's Sixth Amendment right to a public trial and ordered a new trial, where the court, citing courtroom space and generalized security concern, refused to seat a single member of the public during a jury selection without first considering the reasonable alternatives that the law requires. Because Stricker was designated for publication under Texas Rule of Appellate Procedure 47.2b, it is published memorandum opinion of this Court of Appeals and thus the most directly applicable appellate authority on the public trial question. And having been issued months before this trial, it was available for the trial court's review when the court entered the amended order and closed those proceedings. But they weren't closed. They were limited but not closed. The closure here was therefore not the resolution of an unsettled question. It ran headlong into a recent published decision of the very court that reviews this one. Every justification the Fifth Circuit or the Fifth Court rejected in the Stricklers is a justification the court invoked here, and that rejection was on far more extreme facts. There, the court refused to seat one observer because the veneer filled the gallery. Here, the court rationed the general public to roughly 24 rotating seats across every stage of the nationally watched murder trial. There, the trial court disciplined to split voir dire to make room, explaining, I am not going to spend 2 days picking a jury. The Fifth Court held that space and overcrowding through legitimate concerns must not outweigh a defendant's Sixth Amendment rights because there are readily available alternatives, and that neither convenience nor judicial economy can constitute an overriding interest. Here, the record and the court's own public statements at least rise fact issue that reasonable alternatives exist, including a larger or additional court space, a live audio or video feed, and the overflow accommodation the court used during jury selection and then withdrew. And where the stricter court faulted the trial judge for failing to identify a specific concrete fact of danger. I can screenshot a bunch of social media that shows danger, but on this case, but that's just me. The order here rests on the same generic recital that unrestricted access may compromise security entered without a hearing if excluding a single member of the public from jury selection required a new trial and stricter than the recurring exclusion of numerous members of the public from testimony and punishment after the court withdrew an available overflow alternative and made no Waller finding cannot be dismissed as trivial. But they allowed people in. So there's a little bit of a difference. Like I said, even if, let's say this arguing, yeah, it wasn't closed. And I like the overall premise of this. I do. The thing is even if Karmelo Anthony, let's say, gets a new trial because of the appeals court, because it's not going to be because of this motion. It's going to have to be somebody else completely. Karmelo Anthony is still going to be convicted. He's not going to get off on a self-defense claim. It's just, that's not happening. Could he be, if he gets a new trial, convicted of manslaughter? Possibly. But I don't know, because this didn't seem accidental. It wasn't like they just, like, it'd be one thing if he punched him, and then because he punched him, Austin fell back and hit his head on the concrete and then he died. That would maybe be some manslaughter. But to me, he's still going to be convicted of murder. Now, could he get lighter than 35 years at a new trial? Maybe. He could also get more than 35 years if he gets a new trial. So this might be be careful what you wish for. But if the appeals court was like, yeah, this 26 people being let in is not good enough, y'all need to make it more accessible. As a Texan who wants to watch some Texas court proceedings, I would not be mad about that. That's just me. I don't think it's going to happen, but it could. All right. So a second court of appeals reached the same result weeks later on facts material indistinguishable from the space rationale invoked here. Hernandez v. State, the 14th Court of Appeals reversed a capital murder conviction and ordered a new trial because the trial court closed voir dire to the defendant's family in the public. Yeah, that didn't happen here, though. The family was allowed to attend for voir dire. Citing an 80-person veneer and lack of physical space without conducting Waller analysis, making findings, considering reasonable alternatives. Yeah, this is not what you have here. So, must not weigh the defendant's Sixth Amendment rights and admonish that the trial courts are expected to know and apply this basic rule. Thus, recent published Texas decision holding space closed jury selection. That closed jury selection wasn't a problem in this case. So, okay. Court of Criminal Appeals has likewise reversed on a narrow version of this problem. Court reversed a conviction and ordered a new trial because a trial judge excluded the defendant's family. This is not that. I'm not even going to read that. Generally space. Not one family, but not from every stage. May compromise security. Okay, I don't think that applies here. Sixth Amendment to the United States Constitution guarantees the accused in a criminal prosecution the right to a public trial, a guarantee applicable to the states through the 14th Amendment. Texas Constitution independently secures the same right, providing that the accused shall have a speedy public trial. The proceeding and trials shall be public. The right to a public trial is not confined to the presentation of evidence. It extends to jury selection. Before trial court may exclude any public from any part of the criminal proceeding, it must satisfy the 4 tests of Waller v. Georgia. The party seeking to limit access must advance an overriding interest that is likely to be prejudiced. Any limitation must be no broader than necessary to protect that interest. The trial court must consider reasonable alternatives to closing in the proceeding, and the trial court must make finding adequate to support the limitation. The trial court bears the burden of considering reasonable alternatives. The balance of interests must be struck with special care, and finding by trial court are the linchpin of the Waller test. The right of public access applies with the particular force to selection of the jury, has held that the guarantee of open criminal proceeding reaches the voir dire of prospective jurors. Because the selection of jurors has presumptively been a public process, with the exceptions for only good cause shown, open jury selection was the settled practice in America when the Constitution was adopted. Closure of the jury selection is therefore permissible only on same showing of overriding interest. Talking about bringing that Waller's thing in. 10 minutes a day did not keep this courtroom open to a public. Full closure is tested under all 4 Waller. Partial closure is tested under the same factors, with the first requiring a substantial rather than an overriding reason. The only true, trivial, or de minimis restriction leaves the public trial right unimplicated. The court's amended order regulating trial proceedings, media access, security, and courtroom decorum was not a trivial restriction. It provided an pertinent part. Yep, and then he recites the order that he recited before. Then that didn't, I mean, this is repeating itself. The govern the jury selection process, the guilt and innocent phase, the closure, therefore pervasive rather than incidental, depriving public access at every stage. Cumulative and practical effect of these provisions was excluded members of the public from the proceeding. including all phases, basically. The defendant bears the initial burden to show the trial was closed to the public, but the burden is carried on totality of the evidence, and the inquiry does not turn on whether the defendant can show that any particular person was actually excluded. Holding the initial burden rests on the defendant and reaffirming that closure is determined from the totality of the evidence rather than whether a spectator was actually excluded. The focus is not on whether the defendant can show that someone was actually excluded. The reviewing court instead asks whether the court fulfilled its obligation to take every reasonable measure to accommodate public attendance. Here, the cumulative effect of the 9 media cap, the 10-minute public entry window, space available seating, and no re-entry rule, and the absence of any overflow room or live stream established that members of the public were excluded. And the defendant has carried his burden to show that the proceedings were closed. The facts are further established by the accompanying declarations of members of the public who sought to attend trial and were denied entry into the courtroom. Wah, wah, wah. The declarations executed by members of the public who came from across the country to attend established the closure concretely and consistently, and no witness observed any disturbance or security incident that would explain it. And then he talks about the people that were traveling again. Why are you restating all this shit? Okay. Yeah, you said all that. So now this didn't need to be 193 pages. One member of the public attended the trial nearly in its entirety, provided a day-by-day account that corroborates each of these features from the inside. Nakia Washington traveled from Cincinnati, Ohio, and was present in the court day on 1, 3, 4, 5, 6, 8, 9. During jury selection, the court used an auxiliary viewing room, the memorial room, that seated roughly 60 members of the public and carried a live video audio feed of the proceedings. June 4th, the first day of testimony, the public was informed only after arriving that the overflow room would not be available. Access each day was governed not by the order's admission time, but by pre-dawn line that formed as early as 4 to 4:30, was counted off in groups of 27, and was inconsistent, at times chaotic. And although Miss Washington ultimately gained entry on each day she attended, she was excluded from the morning proceedings on both June 4th and June 5th. Guess what Sarah Fields was too on one of the days? Admitted only in the early afternoon after substantial portions of the day had already passed, so that even attending member of the public was denied access to significant parts of the trial. She observed no disturbance or disruptive conduct inside the courthouse. No, all that was happening outside the courthouse, and they didn't want it to be brought into the courthouse. I think that's what you're not getting. This case not controlled by the decisions on which the state may rely. Dixon v. State, the Court of Criminal Appeals held that a public trial right is forfeitable and that a full courtroom standing alone does not violate the guarantee because the right does not require the court to seat every person who wishes to attend. Defendant does not contend otherwise. The violation here is not that the courtroom filled, it is that the court adopted in advance and without case specific findings a reoccurring access regimen that limited the general public to a 10-minute daily entry window. But stop talking about this 10-minute daily window, because in that 10-minute daily entry window, there were more than 27 people out there that they could get in. So that 10-minute window was enough to get the people in that were allowed to come in. Doesn't matter if it was 10 minutes or 30 minutes. The people that they had enough seats for were counted to that. Okay, you're 27, so 27 and further back, you can't come in. 1 through 26, you can come in this 10-minute window. 10 minutes doesn't mean shit. They're just saying it to try to be extra and dramatic. One witness against some otherwise silent record. Here, the closure spans the testimonial phase of the trial, and it's established by 7 mutually corroborating sworn accounts by written admission of the court's own appointed officer that there is no overflow room. Okay, why do we keep repeating this shit? Nor is Williams v. State treated, in which the Court of Criminal Appeals treated the brief exclusion of a single family member during one witness testimony, mitigated by live video feed to the neighboring courtroom, as trivial. The restriction here was the opposite of trivial. It was a single brief exclusion tied to one witness. It was not accompanied by any live feed, and it was not supported by witness specific findings. Okay. How much longer does... Oh my God. They're still talking about... Jesus Christ. I want to see where he gets to a different point. Here we are, still going. Structural error. What is this one? We're still talking about the public viewing the trial. Yeah, I think there should have been a page limit. Okay, so they go on to page 48 about open courtrooms and the public not being allowed. And Waller, and that he needs a new trial because this should have been open to the public. I don't know why we needed like 30 pages on public trial. This motion for new trial page limit, Texas. That's the problem. There's not a fixed page number for motion for new trial. Rather, rules focus on the content and form rather than a strict word or page count. However, courts generally accept clear, concise language, well-organized sections, supporting evidence. Because motions are reviewed for legal sufficiency, it's best to keep the motion focused on the legal grounds and relevant facts. A typical well-argued motion for a new trial in Texas is 1 to 3 pages for civil cases and 2 to 5 pages for criminal cases, depending on the complexity. Yeah, this is absurd. There is no reason that this should be as long as it is. You did not need 30 pages to write about public trials. Cite your cases. Do all that. Like, and you repeated a bunch of shit. Like, you were just repeating the same shit over and over and over again. So I guess I will see if there's anything interesting within those pages, because we ended on like page 22. And I don't know that I want to go on to page 48 reading about why there needed to be more of a public trial. Again, I don't necessarily fully disagree with we need more public access. I don't know that it made it to where he didn't get a fair trial, but that's not for me to decide on this, but I don't think we need to do it in that many pages. Clear and concise. Like, you're talking in circles here. I really think David Gingras. Okay, that is where we're going to end it. It says that it's page 44 of 63. So I guess 63 is the actual motion. And then the rest of the 193 pages is exhibits. From like 64 to 193 is maybe exhibits. I don't know. I know part of it is a transcript. And if we can watch a video, we will do that. So we will continue this another night. Because, oh my God, this is a crazy amount of pages. What else can you say at an evidentiary hearing that you didn't say in these papers? Why can't it be ruled on these papers? You wrote and wrote and wrote. But we're going to look at this because, like I said, I call balls and strikes here. And I want to see what they have to argue. Is there things in here that I didn't know about that I'm like, oh, that's a good argument? I don't know. I don't know that he knows, because all he has is a bunch of people telling him what happened at court or outside court and all that. He doesn't actually have the trial transcript to make meaningful arguments, in my opinion. But sure. Okay. But I will see you guys tomorrow. Y'all have a good night. Bye.